Mama's in the living room watching Judge Judy. I'm in the kitchen eating leftover sushi, and she yells, "Oh, girl, you gotta hear this one." A man was arrested for running the theme park, and when they said, "Where's your license?" he said, "My dog ate it." Oh, you can't make this shit up. Sometimes I wonder if life's just one big cosmic joke. It's like she's on a Reddit, reading r/funny lawsuits, yelling from the couch. As she sips on a Prosecco, makes fun of all the weirdos, and then I hear her shout. Yeah, shout. It's like she's on a Reddit, reading r/funny lawsuits, yelling from the couch. As she sips on a Prosecco, makes fun of all the weirdos, and then I hear her shout. Girl, you gotta hear this one. Mama loves to laugh at how absurd life is, says it's all a comedy and I'm her audience. And I love the way she makes fun of the world. She said, "You'll never guess who's with their girlfriend. It was a man who didn't get us out of the bed. He said, I've been through hell and now I need some help. You just can't make this shit up. You just can't make this shit up." Sometimes I wonder if life's just one big cosmic joke. It's like she's on a Reddit, reading r/funny lawsuits, yelling from the couch. As she sips on a Prosecco, makes fun of all the weirdos, and then I hear her shout. Yeah, shout. It's like she's on a Reddit, reading r/funny lawsuits, yelling from the couch. As she sips on a Prosecco, makes fun of all the weirdos, and then I hear her shout. Girl, you gotta hear this one.
All caps means you're either panicking or trying to represent yourself in court. Both are mistakes. Your feelings are adorable, but they're not admissible, persuasive, or even interesting without evidence. Yes, Heather hates immunity doctrines. It's a personality trait at this point. You don't need to remind her, she wakes up angry about it. Bring receipts. No, I heard it from so and so. This is quid pro quo, not next door. Screenshots are statutes only. Don't fight each other. Fight the law. It deserves it more. If you're offended, excellent. That means you're awake, paying attention, and probably new here. No diagnosing the host. She's petty, not pathological. And don't diagnose anyone else. Stay in your lane, please and thank you. Do not summon the mods. They're tired, hangry, and may bite when provoked. Disagree loudly if you must. The algorithm eats drama for breakfast. Just keep it cute while you argue wrongfully. If you're taking screenshots of my chat, touch grass, tell your handlers. I said hi and find a hobby that isn't me.
She said, "I'll take the heat." And the judge said, "Okay." No acquittal, no new trial, and now you're a felon. So what does that mean for the fact that she's supposedly a judge in the Milwaukee County Circuit? And here's the part about all this that actually matters. This isn't about immigration, so I really don't give two flying Fs what y'all think about immigration. This wasn't about politics. It's not a left or a right. This came down to one question. Did she use her position to interfere with a federal proceeding? And the court just answered that question for us. This document was posted on the 6th. It has been in the news all over the state of Wisconsin. And we're going to look past the headlines as we always do here and read the actual document because it is interesting. in the fact that the judge who wrote this is a very, very, very left-leaning judge. Let me tell you. However, still said no. Still said, suck it up, Buttercup, you're a felon. But let's read the document. And welcome back. If you're new here, I'm Squid Pro Quo, aka Evidence Through Motion, aka anything but late for dinner. Also known as Squid Chup these days because some haters think I'm somebody else or somebody else is me. You know, it is what it is. I've been called worse. I've been blessed by a nun and called the spawn of Satan in the same day. Yes. Actually, like back-to-back patients. But anyway, this is my channel where I do what I want, when I want, and talk about what I want. And we break down documents, so we shift the narrative from the headlines to the facts, because the mainstream media only tells you what they want you to hear, and we tell you the rest of the story. Hey guys, how's chat doing tonight? First-ish. Hey Heidel, I know you're probably lurking. Jeffrey first after the first. I can't find her other channel. I know I was up to it. I don't know if it can be here when this is on. Could someone please let me know the other channel? This is my other channel. This is the link. It is my my Evidence Through Motion channel, where this is my snarky side, and I am feeling very snarky today, so this should be an interesting read. I am pretty sure that the mood I'm in right now, I could take a flip-flop and chunk it from Georgia to Texas and make it in one shot and hit a certain inmate. If you were watching Mo at all in the last 3 days, you know exactly what we are talking about. She mentioned throwing her chancla to Texas from Indiana, so I think I can do it from Georgia. And that case that she is following right now is the reason that I'm not a cop, because Eighth Amendment be damned. But Jeffrey, good to see you. Ninja Puppy, hey everyone. Gail, good to see you as well. Snipe. Everybody, come on in, hang out with us. I do have a QR code on the screen right there. That is the QR code for Tallow Truth. That is my favorite skincare right now. It is helping getting rid of my old lady lines because I am aging. I do not like the way my face is aging, so we are trying to change that. But I'm also trying to go the all-natural route and fix what I put on my face. And that is a code for my link that will get you 15% off. Or if you go to thetallowtruth.com and you use the code SQUID, it will get you 15% off. Not just your first order, but every order. Beef tallow skincare. And no, you won't smell like a steak, unlike what some of my chat tries to convince you. Hey, Andrea, good to see you. Devil fan. Squid Chup in the house. Your skills and regimen reducing that beeline. Yep, this is my WTF line. Quit throwing your shoes my way. A bit two pretty ladies in one. Squid Chup is amazing. Yeah, that's the funniest thing. I love ketchup, don't get me wrong. Both the person on YouTube and the food. But just saying, like, I just find it funny because, like, she's nicer than me. So I don't know why the flea bags thought I was her, because she's nicer than me. She's a much better person than I am, I will just say. But yes, that is my link. All right, so let's get into this. This is a large document, but we are going to try to read it the best we can. We are going to skip some of the stuff that we have known for. We're going to skip some of the stuff that we already know. If you do not know who this is Hannah Dugan. She is a Milwaukee County Circuit Court, well, was a Milwaukee County Circuit Court judge, who is now a convicted felon because she was charged with 2 counts and convicted of 1, and tried to file a motion for an acquittal and a new trial. And this is the judge's response. Because she tried to hide behind judicial immunity, and we all know how much I love judicial immunity. That is why I played the petty chat rules, because Heather hates immunity. I wake up pissed about it every day. I hate judicial immunity. I hate prosecutorial immunity. I hate law enforcement immunity. I hate immunity everywhere. No one is above the law, and you should not be able to hide behind being any sort of law enforcement on any level because you have that position. No, 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 no. Yes, judges are finally starting to learn what accountability is truly like. Yes, it's a. So we are in a very petty mood tonight. So, hi, Kingdom, how are you? Didn't see me say hi. Sorry. And Lori, good to see you as well. All right. This is 39 pages. So like I said, we are going to skip the parts that are blatantly obvious and that we don't need to rehash. I have a whole Hannah Dugan, USB Hannah Dugan playlist if you would like to see any of that. And there we go. All right. Jury convicted Hannah Dugan, a state court judge, of obstructing a proceeding before the Department of Homeland Security, contrary to 18 U.S. Code 1505. Defendant moves for judgment of acquittal and for a new trial. And for the reasons below, her motions will be denied. Sit down. Denied. No new trial, not pass go, do not collect $200. You are now a convicted felon. The government obtained a 2-count indictment charging defendants as follows. Knowingly concealed EFR, a person whose arrest and warrant and process had been issued under the provisions of law under the U.S., so as to prevent the discovery and arrest of EFR after notice and knowledge of the fact that a warrant and process had been issued for the apprehension of EFR in violation of U.S. Code 1071. And count 2, that Hannah Dugan did corruptly endeavor to influence, obstruct, and impede the due and proper administration of the law in which a pending proceeding was being had before the department and agency of the U.S., namely the administrative arrest of EFR, for purposes of removal proceedings conducted by the Department of Homeland Security by committing affirmative acts to assist EFR to evade arrest, including confronting members of ICE task force and falsely telling them that they needed a judicial warrant to effectuate their arrest of EFR, which they don't. Upon learning that they had an administrative warrant for EFR's arrest, directing all identified members of the ICE task force to leave the location of the planned arrest, a public hallway outside her courtroom, and go to the chief judge's office, addressing EFR's Milwaukee County Circuit Court criminal case, which was, I believe, a DV case, if I'm remembering correctly. So she's not just concealing someone who's here illegally, but she's also concealing someone who's been accused of domestic violence. There's just whatever you think of immigration, whatever, you are concealing someone who is being charged with domestic violence. What kind of shitty human being are you? Where you will protect someone that is being charged, yes, innocent until proven guilty-ish, but my petty side wants to come out, but I would like to keep this stream monetized because this is how I help my family put food on the table. Because my second channel is not monetized yet. Maybe someday it will be, but for now, this is what I got going. And if I tell you what I truly think right now, my channel will no longer be monetized. Holy crap. Yeah, it's like just because Ketchup and I are from the same state that we sound the same. It's like every Wisconsinite sounds the same. That's like saying just because certain people look the same that they sound the same. You know what I mean? I kind of do, but then again, I kind of want to keep this thing going because it's entertaining. And I'm sure Ketchup and Jay and Coop and everybody's feels the same way because this shit is just freaking entertaining. Like, are you not entertained by the utter ridiculousness of thinking that everyone is everyone else? Venom is this person. Venom is this. No, Venom is this person. Spawn is this person. No, Ketchup is this person. Squid is this person. Y'all realize I have 2 actual channels where I tell you who I am on camera. I do not have time, even if I wanted to keep up with alt accounts. I can barely keep up with the 2 accounts I actually have. Oi. Oi. Hey, you mean, so in Mo's stream a little while ago, because the difficult nature of the topic and the fact that we wanted to throw our computers and phones and whatever devices we were on against the wall, because this person had unalived a 7-year-old girl but wanted to go home for Christmas to see his son. The audacity on clearance, I swear. The audacity that some people have is just ridiculous. But because of that, there was 3 or 4 Wisconsinites in the chat, and we all started talking about cheese because I was cooking dinner, which I haven't eaten yet. Based on the last election, me too. Which is one of the reasons that this case was interesting to me because I lived in this county. Yeah, you were so entertained by that ketchup squid thing that you skipped my appointment. You. I'm glad you got out of it. Yeah, me too. The unmitigated gall. Yeah, JKD Buck was there. Roy was there for a little bit, I think. It's not, I know Gail was there. It was that is not a hold on. I'm not in trouble. Just had a situation. You read lips. Okay. So the Mr. Squid was doing his thing, you know. After a long day, you like to take a shower, and the little went into the bathroom, got undressed, and climbed in the shower and took her first shower. What? My little girl is growing up. My little girl took a shower instead of a bath and didn't cry. What? What? Like, what? What just happened here? He opened the door and she's wrapped in a towel. I'm like, okay, well, no bath tonight, I guess. But the things that happen in this house make me smile. All right, getting back to this document. Pretty much. Pretty much. All right. So this was where it got interesting, addressing EFR's court criminal case off the record while the ICE task force members were in the chief judge's office, directing EFR and his counsel to exit courtroom 615 through a non-public jury door, and advising EFR's counsel that he could appear by Zoom for his next court date. Defendant filed pretrial motions to dismiss. This is where I lost my shit. She enjoyed absolute judicial immunity for all the acts alleged in the indictment. No, bitch, that's not what the judge said. That's not what 2 judges said, a magistrate and a district court judge. And then the jury said, no. And now the district judge, again, who is very left-leaning and probably doesn't like the fact that ICE was in Milwaukee County anyway, still doesn't think that you get judicial immunity for this. Suck it the fuck up. The prosecution violated the 10th Amendment of the Constitution's vertical separation of powers by intruding on the authority of state judges to manage their own courtrooms and proceedings. The audacity. This is like, people be getting their audacity on the clearance section. Or somebody said in another chat, they got their audacity at Temu. It's like wish.com. Oh, okay. And should be construed as to avoid the constitutional issue she raised. The magistrate judge handling pretrial proceedings in this case recommended that the motion be denied, and after receiving briefing, I adopted the recommendation and declined to dismiss the indictment. After surveying case law, I concluded there's no general rule of criminal immunity for judges. No criminal immunity. You are not immune for criminal acts. Judicial immunity goes back to 1607, England, for a court case where someone lost and then tried to sue the judge because they lost a case. That is what judicial immunity is supposed to be, and that is the only appropriate that I can think of offhand. Is the only appropriate time where judicial immunity is fair. Sarah Boone lost her case. She cannot sue Judge Cranick because she lost. It's not how that works. However, criminal acts don't save your ass. Sorry, lady. What? Oh. I conclude that there's no general rule of criminal immunity for judges, nor was there a basis for granting immunity simply because some of the allegations in the indictment described conduct that could be considered part of a judge's job. The phrase right there, could, not is, could. Like, that's always always an issue. Like, the way people talk and the words they use are very important. And when someone tells you who they are, believe them. Yes, immunity for job duty is not code of ethics. That was another problem. Even if she wouldn't have been found guilty by the jury of this, I believe there was a huge ethical issue. Huge ethical issue. I had this conversation with my dad today that we should not know the political affiliation of a judge. But yet, we do. If judge releases an animal, said animal should be required to live with the judge. I got one better for you, because I got one more realistic. If a judge releases an animal and the animal commits another crime, the judge should be on trial as an accessory to that crime, because they are the reason that that crime was able to be committed. If the judge would have done the job the first time, that never would have been possible. Maybe a little more realistic than living with the judge, but should be considered an accessory to the crime. So, prior to the trial, parties filed motions in limine. As pertinent here, defendant requested an order that the government could not rely on her lawful official acts to sustain charges. She cited cases holding that an act one has a legal right to undertake does not obstruct or hinder. She cited all civil cases, if I'm remembering correctly. In these cases, courts recognize that corrupt interference with an investigation would not exist where a mother suggested her son invoke his right against compelled self-incrimination, a wife persuades her spouse not to disclose marital confidences, or a lawyer counsels the client not to turn over documents pursuant to a valid claim of privilege. So we're skipping the case law, but defendant argued that because she had a legal right to do each of the 5 acts alleged in the indictment, all within the scope of her authority as a Wisconsin state judge. Hoy vey. Yeah, breaking the law is not covered under judicial immunity. Yes, and I'm hoping that this will be case law. They're supposed to everywhere, even in Wisconsin. Technically speaking, They don't. But if you Google them, they will have a letter next to their name based on who is supporting them. Who backs this candidate? Yeah. So it's just an interesting situation where it's like I'm hoping that this case, and this is one of the reasons it was so interested. Not only is it in my hometown, um, hometown-ish general area, but it could set precedent for other judges who decide to act out of pocket and think that they have all the leniency and judicial immunity in the world. And no, they don't. No, they don't. No, they don't. Sorry, I have to adjust my band. I have this little metal piece is right in the side of my arm, and it's kind of hurting. There we go. Oh, there necessarily was no consciousness of wrongdoing. Y'all, I haven't had a drink all year, but this bitch makes me want to drink. We haven't even covered the transcripts that I have of her court case because she annoys me so damn much. The audacity and this is white privilege right here. This bitch is white privilege. This bitch is liberal privilege. This bitch is judicial privilege. Like thinking that you're better than someone because of your position. Thinking that you can do whatever the hell you want because you have a certain position. The fucking entitlement. Y'all, I'm on another level. The effing entitlement. No one in this world is entitled to shit. I don't care if you're a judge, you're the president, or you're my next door neighbor, or you're my best friend. Like you're Felisa. You're not entitled to anything, especially anything that anybody else has. Ew, the audacity. Yeah, when she said I'll take the heat, she knew she was breaking the law. That right there. Well, that's why when I remember that I'll take the heat quote was like, well, the judge said okay. The jury said okay. 2 judges, a magistrate and a district court judge, all said okay. Have fun. Cock is the word entitlement. It's just woman privilege. I don't know. Like, I don't know. There's like 3 levels of privilege right there that you could attach to her if you want to play the identity cards. All right. She accordingly moved to exclude all government evidence that she impeded or any way hindered within the scope of counts 1 and 2 the efforts of federal agents to arrest EFR in a state courthouse's public hallway. This wasn't her courtroom. I could see not wanting stuff to go down in your courtroom. Like your courtroom is a safe space. Though I feel like I just lost IQ points saying that. I'm starting to get that line back. Where's the little probably took it somewhere. I usually keep one on my desk. That's the thing though. In the original indictment, the U.S. was never looking for jail time. They were more looking for her to not be on the bench anymore. And accountability that she is now convicted. Because I believe these were felonies. So she only got convicted of 1 count, but it was still a felony, if I'm remembering correctly. So she's now no, but for the judge, it is a space that she is in charge of and she can manage. But this was not her courtroom. This was outside her courtroom. So she doesn't have control over the freaking hallway outside her courtroom. Now, I know it's not a safe space, but it's a place where she has control. So her safe space where she can control the outcomes of situations. The hallway, not your area of concern. So that was my only That was my only point about safe space, is an area where she has control of. Like, she'd wanna get rid of all their evidence. Like, "Here you go." Um, the government responded defendant's motion in limine would affect, confer partial judicial immunity, and put much of the government's proof off limits. I agree that the correct approach was to permit the jury to consider all of defendant's conduct on April 18th, 2025, in deciding whether she concealed an alien under 1071 or corruptly endeavored to obstruct a proceeding under 1505. I further explained that the cases upon which defendant relied did not suggest a different result. Edwards and Matthews were jury instruction cases, construing the term corruptly to wrongly require wrongful conduct, not immunity cases, placing official judicial acts outside the scope of the statutes. She applied the case law wrong. How is a judge who is a lawyer and has a lawyer still apply case law wrong? That is how you know that you do not have a case. That is how you know that there is no case law supporting your position. Is all the case law she cited has nothing to do with her issues. Like, I am not a lawyer. I will never claim to be a lawyer. But you look at that and you're like, this is a civil case. This is a jury. Your case is not about jury instructions. Your case is a criminal case. Your case is not a civil case. Like, the case you cited has absolutely nothing to do with the facts of your case. It's like, how stupid are you? Or how the audacity to even think that that was gonna fucking work and pay for legal counsel? Just saying. Like, uh-oh. And JKD Buck, thank you for the picture you sent me, the holy freeze frame. I wish I could show this to y'all, but I'm gonna try to. So JKD Buck decided to pause the stream for whatever reason. Bless his heart, gotta pee, gotta get a drink. Mrs. JKD Buck needed his attention for whatever. This is how he paused me. I mean, okay. Love y'all. I love y'all. Usually I don't check my messages during the middle of a stream, but I could, when it's from someone who's in chat, I could not help myself because there's a reason. I had to drink. Oh my goodness. Yeah, at least I'm ballsy enough to put myself on camera. I understand there are a lot of people who don't, and that's fine. But there are some people who don't specifically for reasons. Just saying. You might break the camera if you turn it on. Ugh. They need to have, just like any job, ethical responsibility for immunity to be granted. And you would think, being lawyers and having to take ethics classes and all of that, and being, American Bar Code of Ethics, the State Bar Code of Ethics. Shut the fuck up. You were on camera on my stream. Shut the fuck up. That's the stupidest comment ever, and I'm timing you out for that. Someone timed him out for 30 seconds for that comment, because that was self-deprecating and not in a funny way. Outpost nerd, you are not ugly as fuck. So stop saying that right now. I will reach through this freaking camera and smack some sense into you. If you actually believe that, you're full of crap. All right. And as the Seventh Circuit has explained in rejecting similar arguments made by a lawyer, it's not the means employed by the defendant that are specifically prohibited by the statute. Instead, it is the defendant's corrupt endeavor which motivated the action. Otherwise, lawful conduct, even acts undertaken by an attorney in the course of representing a client, can transgress 1503 if employed with the corrupt intent to accomplish what the statute forbids. This case law holding means through lawful in themselves can cross the line of illegality if employed with a corrupt motive. Like saying, I know I'm doing something wrong. I'll take the heat. Don't worry, guys, because I'm a judge who can hide behind immunity. Don't worry. Don't worry. Oh. Explaining your T-Rex arms are too short. Shut up. Someone in the comment section one time called me mean, and they couldn't watch my streams because I was mean because I called someone who I didn't like and didn't like me a beached whale, and that was the audacity of me saying that was too much for them. Judges do not care about ethics when it comes to themselves, only when someone acts out in their courtroom. Yeah, I'm hoping that, like I said, this will be precedent for future cases because this is a federal case, can be used by a lot of people and won't be that hard to find because it's been so publicized. Sorry, man. Yeah. And I'm sorry too. We just had to get rid of that comment because no one needs to see that comment. So, you know. I'm in a mood today. Been harassing Squid across multiple streets. Yeah. Did you time him out for 30 minutes instead of 30 seconds? All right. I decline to reconsider my previous ruling on the immunity motion or to adopt an evidentiary standard based on an official-unofficial distinction inconsistent with that ruling. I noted defendant would be free to present evidence and argument that events of April 18th involved the routine work of the state court and judge, and that the government would be allowed to contend that the defendant added extraneous activities to her usual duties in order to defeat enforcement of federal immigration law. When have you ever seen a judge step foot in a hallway? When have you ever seen a judge step foot in a hallway? That would be extraneous activities. Example 1. Without understanding, I denied this defense. The case proceeded to trial December 15th, 2025. In its case in chief, government presented evidence that state of Wisconsin charged EFR with 3 counts of domestic violence battery, and his case was scheduled for a hearing in defendant's courtroom on the 6th floor of Milwaukee County Courthouse. Following his arrest on those charges, ICE learned that he was present in the United States without legal status. Yeah, they're not just looking for random people, and they're not just going door to door. This is the thing about ICE. Like, they're not just knocking on doors for random reasons. This person was arrested, which means his information got put in the system, and it gets generally, when you put it in the system, it gets flagged. Like, oh, there's an ICE retainer. So ICE is aware that this person is in custody. But 3 counts of domestic violence battery. And you are worried about his freaking immigration status? Like, if someone is in your courtroom for DV and they're not supposed to be here anyway, get them the fuck out of here. Come back legally. Don't care. Do it the legal way, like thousands and thousands and millions of other people have. But, like, he was in your courtroom for DV. What about his victims? What about the person what about his victim? You were more worried about him than his victim. That is the other part of this that I just cannot fathom. what about victims' rights? Like, ugh. Oh, and he is gone, by the way. He is out of the country. With a previous order of removal. There's another thing for the people who are anti-ICE. He had a previous order of removal. This was not new. He already was set to be removed from the country. They just needed to find him because he was evading them. And issued an administrative warrant for his arrest. Members of an ICE task force planned to arrest him at the courthouse on April 18th. 6 federal agents, don't need to know their names, arrived to make the arrest, identifying themselves at courthouse security checkpoints. 2 agents also checked in with the bailiff, advising that they planned to arrest him after his hearing. The agents then sat in the public hallway to wait. Public hallway. They observed him arrive and walk towards the courtroom. Upon learning the agent's presence in the hallway from her clerk, defendant left the bench, went to a neighboring courtroom, and gestured for Judge Christina Cervera to come off her bench. Another weird thing. When have you ever seen that before? On entering chambers, Judge Cervera began to take off her judicial robe, but defendant told her to leave her robe on. Defendant said, "ICE is here. We need to check a warrant." Defendant then proceeded to walk down a restricted hallway with Judge Cervera. Defendant was speaking as they were walking, and Judge Cervera testified she heard the name something about Flores. She asked, "Is that someone on my docket?" Defendant did not answer. Cervera followed defendant down the restricted hallway, out into the public hallway. Cervera hesitated at the doorway because she did not want to enter the public hallway with her robe on. Once in the public hallway, defendant confronted 2 agents who were seated on a bench, asking why they were there. One indicated they were there to make an arrest of a person unlawfully present in the U.S., and defendant asked if they had a judicial warrant. They responded they had an administrative warrant. Defendant replied that it had to be a judicial warrant. It did not. It did not. It did not. Defendant then directed them to go to a chief judge's office because Dee did not know where the chief judge's office was, and the chief judge was not there at the time. That's an important distinction as well. She knew that he wasn't there and that they would have to wait. Shocker, right? Judge Cervera offered to walk him there. Defendant approached other federal agents she identified in the hallway, directing them to the judge's office as well. Defendant failed to identify one agent who remained in the hallway. After the agents had been cleared from the hallway, defendant returned to her courtroom and asked, "Which client is it?" "We'll call it right away," she told the attorney seated at counsel's table. Walter Peel, who expected his case to be called first, stepped back. She then turned to Flores Ruiz, telling his lawyer, Mercedes de la Rosa, to take her client out and come back and get a date. She then instructed clerk to just give her a new date. Yeah. Courtroom recording device captured whispered conversation between defendant and her court reporter, Joan Butts, what a name, in which they discussed De La Rosa and Flores leaving through the jury door when defendant sitting down the stairs. She tried to say that he was going to the elevator. The audio heard down the stairs. I mean. Oh. Oh my goodness. Per the courtroom recording, the clerk told defendant there were 5 ICE guys in the hall. There were 6, but that's beside the point. The jury door opened into a restricted hallway leading to 2 doors, one opening to a set of stairs down to the 5th floor, the other back to the public hallway. She wanted them to take the stairs. They made a wrong turn. And screwed her over. Had they made it down the stairs, she might have been able to walk away from this. However, they made the turn back towards the hallway and the elevators. So you tried to protect someone who ended up screwing you over. Just The restricted hallway is generally limited to court staff and jurors. Criminal defendants are not ordinarily allowed to exit through this hallway. Butts ask. Oh, my petty side is like, I don't like this chick, so we're gonna make fun of her. She's probably like 70. She probably needs to retire. You work for a liberal ass judge who you co-signed all of this behavior instead of going, well, maybe this isn't a good idea. Butts asked if she should show them because De La Rosa might go out the wrong door, i.e., the door back out to the public hallway where ICE was, rather than the door leading downstairs. This bitch should be charged too. This is so stupid. Like, why are you protecting someone who is here illegally? I can't understand the need to protect people who have broken the law. Defendant replied, I'll do it. I'll get the heat. Yes, you will, ma'am. Yes, you will. She also indicated EFR could appear by Zoom for his next hearing. Defendant then escorted them through a jury door and directed them down the restricted hallway. They took the door back out into the public hallway because they aren't smart. I mean, this is the person that was charged with 3 counts of DV battery. Can we say not the brightest crayon in the box? Or just, and that lawyer, probably a public defender, not being paid to deal with any of this crap. Like, she's like, I don't make enough money for this. Neither the assistant district attorney nor the alleged victims in the case who were present for the hearing were involved in this exchange. Unaware the case had been handled in this fashion, the alleged victims left after waiting for about an hour. Defendant's handling of the matter differed from how she usually handled cases with victims, including one addressed off the record on April 18th, with defendant typically ensuring compliance with victim notification. De La Rosa testified, the lawyer, she did not know there was an entrance to the stairs from that restricted hallway. Just can't. And this is part of the trial that this was a federal case, so we're not privy to this trial. So this is entertaining. Her husband's name is Seymour. Oh my goodness. All right. So ensuring compliance with victim notification requirements, and that the prosecutor was aware of the new date in the event the victims wanted to be there. On her return to the bench, defendant's clerk asked if they should call the other interpreter cases first. Defendant responded by asking, is there anybody else that looks? Okay. This is another thing okay, like, I am not going to get super political. However, this is another one of those things that irks me. The people who are so anti-ICE and so protect certain people are some of the most racist ass people in the entire world. Finish this sentence that's quoted here and not finished. Defendant responded by asking, quote, anybody else that looks. What are you talking about? Anybody else that looks like they don't speak English? That's a little racist, don't you think? But nope, you're a liberal white woman, so you can do whatever the hell you want, apparently. So liberal white women are the most racist people I've ever seen in my life. And I really don't want to get political, but like, it is perfect fucking example right here. In a court document, the defendant responded by asking, quote, is there anybody else that looks ... Meaning that judge did not want to finish that quote in an official document. Fucking irks me. Tangent. But when someone says, we can't deport all the illegals, who's going to clean our toilets or who's going to build our houses? That is racist. That is a racist ass statement. And the only people I've heard say that shit is liberal white women. So y'all can hate me in the comments. Y'all can light my ass up. I really don't care. Because y'all racist shit. Don't be a racist. Don't be a twat waffle. Don't be like this judge. Be better. Like, sorry. Usually I don't. I try to keep even keeled, but like that pissed me off. That pissed me off so much. That is some racist ass shit. Like, that right there. Freed replied, I'm not sure. Defendant then called Attorney Peel's case on record. Oh, that set me off right there. That was, he didn't want to finish that sentence, but I will dig into the transcripts that I have to see if they're on the transcripts I have, because we will be outing her racist statements. Because my next stream about this judge will be like, is this judge racist? Let's count the ways. All right. Trial 135, 21, 42. Oh my God. Sorry, y'all. Sorry for the derailment, but you can't get much worse. And then they have the audacity to call other people names and ists and that. And it's like, no. This right here, this statement right here. What? What? Yeah, former judge. Like, ugh. The projection, yeah, guilty by projection. Yeah. That's like people need to look in the mirror when they say these words. Meanwhile, Vasconcelos has gone to the chief judge's office with Judge Cervera, proceeding behind glass doors into the office, while the other 4 members of the team remained in the vestibule. He showed Judge Cervera the administrative warrant. He also spoke with Chief Judge Ashley by phone because he wasn't there. He later motioned for another agent to come behind the glass door when he spoke to Chief Judge Ashley, because Chief Judge Ashley was not in his office. They knew that. Squid Chup almost got on a soapbox. Y'all, almost lost my shit. Like, almost lost my shit. The one thing I really, 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 really hate is people being racist and then hiding behind the fact that, oh, I'm just so caring and concerned about people. No, you're also the people that tell Black people that they're too stupid to go to the DMV and get an ID. You're also the people who tell people that live in rural America that you're too stupid to figure out how to make a photocopy, that your phones can't scan a document and email it to somebody. Like, these are the people who claim that women are so smart to be president, but can't name what a woman is. But then call women too stupid to be able to change their ID after they get married. But yet a woman is smart enough to be president, but yet a woman's not smart enough to change the name on their ID after they get married. Fucking make it make sense. It doesn't. Like, it does not make sense to me. Oh, welcome to my TED Talk, where people are stupid and the pronouns don't matter. Oh, A member of the sheriff's office entered the vestibule area, and Ayers heard him say something to the effect of, "She's trying to speed him through." Ayers exited through the vestibule, saw Flores Ruiz and his attorney enter the public hallway, and followed them down the elevator and outside the courthouse. Jeffrey, thanks for the $2 super chat. Thank you for ensuring I didn't work for free. Appreciate you. Oh. All right. Judge Cervera testified that defendant did not follow them to the chief judge's office, which surprised her. She further testified after leaving the chief judge's office, she returned to her courtroom through defendant's courtroom, observing defendant back on the bench hearing cases. She indicated this irritated her. She felt abandoned after being pulled off her bench. She was trying to throw you under the bus. No, I don't think the Supreme Court will hear this case. No. After this document, no. Only if she has a death wish. And when I mean death wish, I mean, some people say no PR or bad PR, but this is super bad PR. You're not going to be, you're never going to be, if this goes to the Supreme Court and more people find out about this that don't already know about it, she will be the laughing stock of everything. She indicated this irritated her. Finally, Judge Cervera testified that later that day, members of the state's public defender's office congratulated her, which she found confusing. One explained, "Just so you know, our client was arrested on 10th Street because we know you guys, what you guys were trying to do." When she learned of the full circumstances, i.e. what the public defenders assumed the two judges were trying to do, Judge Cervera testified that she was shocked. Judges shouldn't be helping defendants evade arrest. She further testified that she felt mortified because someone might think she was a part of what happened. Other members of the team arrived. The agents attempted to arrest Flores Ruiz, but he ran. Shocker. Agents were able to catch him and take him into custody across the street. On the following Monday, April 21st, defendant told Judge Cervera she was in the doghouse with the chief judge because I tried to help that guy. I tried to help that guy. What the hell did you think you were trying to help him from? Himself? Honestly, chica, we got some problems here. We got some problems. Defendant moved for judgment of acquittal, and at the close of the government's case in chief, I reserved decision. And if you've ever watched any case ever before, this is normal. In between the prosecution and the defense will always say that the prosecution didn't meet their burden, and we move for an acquittal. All she did was cost Wisconsin taxpayers a lot of money and give me some fucking good ass content. But this right here is part of the reason that I don't live in Wisconsin anymore. I didn't want to live in Wisconsin anymore. I have no desire to move back to Wisconsin. I have no desire to even visit Wisconsin, even though I have plenty of friends and family there. I don't want to be anywhere near this shit show. The defense called for witnesses, including two circuit court judges who testified about previous ICE arrests in the courthouse and the development about a policy. While the chief judge had produced a draft policy, no final policy had been created at the time of these events. Following closing arguments, I instructed the jury to find defendant guilty on count 1 of the government had to prove 4 elements beyond a reasonable doubt. Federal warrant had been issued. The defendant knew that the federal warrant process had been issued. The defendant actually harbored or concealed the individual, and the defendant intended to prevent the individual's discovery or arrest. I instructed that count 2 also had 4 elements. There was a proceeding pending before a department or agency of the U.S. The defendant knew of the pending proceeding. The defendant endeavored to influence, obstruct, or impede a pending proceeding, and the defendant did so corruptly. Yes. How are y'all just figuring this shit out? This is the reason I cover a lot of Wisconsin cases, because I know crazy because I'm from there. Crazy either happens in Florida or Wisconsin. Corruption happens in Massachusetts. But the bulk of the crazy lately is either Florida man or Wisconsin man. Ugh. This is another thing that she tried to do. This is another thing she was trying to do, is change the definition of pending proceeding for use in this trial. For count 2, I explained the term pending proceeding simply means any process taking place in the manner and form prescribed in the conducting business by or before a department or government agency, including all steps and stages. There's an important distinction. Steps and stages in such an action, from its inception to its conclusion, from the arrest to the plane ticket. I further explained that endeavored means to have acted purposefully with knowledge that an action would have a natural and probable effect of wrongful obstructing a proceeding. An endeavor need not be successful. You don't have to be a good criminal to be a criminal. That was one of the distinctions that I made when she kept making the argument. Well, he was arrested anyway. You don't have to be a good criminal to be a criminal. I mean, they've made TV shows out of it. Remember Stupid Criminal? Like, there was a TV show called Stupid Criminals or Stupid Crimes or something like that. Like, it's, or World's Dumbest Criminals. I almost got away with it. Things like that. Finally, I explained the term corruptly means acting with an improper purpose, personally or by influencing another, including making a false or misleading statement. World's Dumbest. Thank you. I knew there was... Gosh. We had a 20-minute conversation with me and a couple other people about cheese in Mo's chat. So don't get me started. During deliberations, the jury asked, as per page 19, bullet point 2, we desire clarity as to whether or not Judge Dugan needed to know the identity of the subject of the arrest warrant, for example, his specific name. After hearing from counsel, I responded that in order to commit the offense charged in count 1, the defendant needed to know the identity of the subject of the warrant. Later, they asked, element 2, we desire clarity as to whether Judge Dugan needed to know the identity of the subject of the proceeding. No. I responded to no of the proceeding. The defendant needed to have sufficient knowledge about the nature of the proceeding. Jury found the defendant not guilty of count 1 and guilty of count 2. She renewed her motion for acquittal and added in the alternative a request for a new trial. The matter is fully briefed and ready for a decision. Oh. Yeah, owie. Yeah, my daughter. This is definitely my daughter poking me in the eye and then laughing about it. Oh. You got. All right, let's see if I can. If I start crying, it's because she hit me right there, and it's like right on the right under the bone, like she was trying to stick her finger behind my eyeball. Oof. All right. Yeah, this is what I was thinking too. All right, review standards. Defendant seeking an entry of judgment of acquittal under Rule 29 faces nearly an insurmountable hurdle, as the court defers heavily to the jury's findings. All right, Rule 33 permits district court to vacate a judgment and grant new trial in a criminal case if interest of justice so requires. Courts ordered new trials under Rule 33 in a variety of situations in which the substantial rights of the defendant have been jeopardized by errors or omissions during trial. It's not the case here. The evidence was sufficient. Viewing the totality of the evidence that the government presented in this case, it is sufficient to provide a rational basis for which a jury could find guilt beyond a reasonable doubt. The government demonstrated that April 18th, agents arrived at the courthouse to arrest EFR pursuant to an administrative warrant. That's all they needed. And a step in his pending removal proceeding. The government further demonstrated that the defendant was made aware of ICE's presence and the administrative warrant. The government showed, basically just going through it all again. We're not going to go through all of it again. I'm in the doghouse with Carl for trying to help that guy, Carl being Carl Ashley, the chief judge. This is what made me cringe at one of her motions. In the original motion for acquittal, defendant argued that there was no pending proceeding because EFR's removal proceeding had ended. No. Based on what the judge said, a pending proceeding means it means start to finish. Arrest or ticket out of here to plane ticket out of here. Actually being removed. You need to explain this like a toddler. I'm sure my toddler would understand this better than the judge, former judge. However, defendant does not address the testimony from Supervisory Detention and Deportation Officer Anthony Nimitz discussing the steps in a removal process, which in this situation began with his arrest in April of 2025 and concluded with his actual removal in November of 2025. Government presented a similar testimony from Assistant Field Office Director Cassandra from another agent. Defendant notes the agents did not testify. She told them they needed a judicial warrant. However, Cervera testified the defendant did make this statement, repeating it 3 times. The jury is free to accept her testimony. The evidence in the original motion, defendant argued she pointed him and his lawyer to the door to the public hallway, not the door to the stairs. However, a reasonable jury could find, based on her conversation with the court reporter, that the defendant intended to take the door to the stairs, but Attorney De La Rosa used the wrong door. Scheiße. Oh. Defendant's argument. I address each in turn because she challenges the verdict. Privilege against civil arrest in courthouse. Defendant argues she committed no crime because ICE arrests in courthouses violate the common law privilege against the execution of civil processes or civil arrest warrants on a party appearing in a courthouse. Civil. This is, last time I checked, breaking the immigration law was a criminal code. That's just, distinction. Civil, criminal. Like I said. Hey, Mom. I went on a soapbox about how this judge is a racist thunder cow. But that's about it. She contends that because ICE had no legal authority to act on an administrative arrest warrant within the courthouse, she did not unlawfully impede the execution of a civil warrant in that building. Oh, you're dumb. Defendant relies on district court decisions applying common law privilege to civil ICE arrest in courthouse. As she acknowledges, only circuit court to address the issue had rejected her position that such arrests violate privileges. Noting that the privilege has never been thought to protect against criminal arrests. or other forms of criminal processing courthouses. She argued against herself. This is where if you give someone enough rope, they will eventually hang themselves. This is where if you let someone talk, this is one of the reasons that even though some people that come into chat, I might not personally get along with, I will let them come in and say whatever they want to. Because sometimes if you let someone talk, they will contradict themselves. And if you read enough court documents, you will see lawyers or even pro se defendants contradict themselves from paragraph to paragraph. She had put in case law in her motion for acquittal that they had no right to act in a civil arrest warrant or civil processes, but yet admitted that her case law did not cover criminal proceedings or criminal arrests. Y'all, breaking the immigration law in this country is a criminal offense. It is not a civil offense. It is a criminal offense. She argued against herself in her own motion. The absolute most, dense shit. It proves that you do not have to be smart to be a lawyer. It's it's just... Oh, hey, Ronnie, how are you? Oh my goodness. It's just oh my God. Sometimes you just look at shit and I'm like, did you read this before you submitted it to the court? Like you're this is what we're going with. Like, this is really what we're going to go with. It's like when I let my daughter pick out her own clothes the other day and she picked them out. We got dressed and it's like, are you really sure that this is what you want to go with? She acknowledges the only circuit court to address the issue has rejected her position that such arrest violates privilege, noting that privilege has never been thought to protect against criminal arrests or other forms of criminal process in the courthouse, arguing against your own position. Stupid. This is why we share everything, because you will hear on the news that the judge denied her motion, but you will not hear the ridiculousness of her arguments and how stupid lawyers are and how stupid this judge was until you read the documents. And then you're like, how did you ever think that this was a good fucking idea? And if you are going to do something like this, I don't recommend it, but have we not learned? Do not talk about our crimes, especially if they're being recorded, like in courtroom audio. Hoy, so dumb, but yet so funny to read. Brian Court explained, just as criminal arrests are implicate of the uniquely sovereign interest in enforcing the penal laws and protecting the public, so too do civil immigration arrests seek to vindicate similar kinds of interest in controlling immigration in the presence of non-citizens in the country. Defendant counters that purpose of privilege is to protect the court as an independent branch of government. If the court is an independent branch of government, which it's supposed to be, why are you interfering with the executive branch of the government who's supposed to enforce the laws? Why are you interfering with another branch of government doing their job? The holding in Ryan wholly ignores this purpose. Civil arrest, whether by a private individual or by the government, runs afoul of this privilege of the court. She's... Oh. Sing it, Heidel, sing it. The executive may have sovereign power over immigration enforcement, but the executive did not have sovereign power over the court. Holding that 1952 Immigration and Nationality Act did not displace the common law privilege. Defendant continues that here her actions were on behalf of the court itself. She contends that by donning her robe and directing the agents to the chief judge's office, she acted within her judicial authority. She concludes that because Flores Ruiz had a privilege to come and go from his court appearance without the execution of a civil arrest, there could have been no obstructing or impeding. For two reasons, I reject the defendant's argument. First, I agree with the government that the defendant waived the argument by failing to raise a via pretrial motion. Certain motions must be raised pretrial if the basis for the motion is then reasonably available and the motion can be determined without a trial on the merits. Among these are motions alleging the defect in the indictment, such as failure to state an offense. Here, defendant filed a detailed pretrial motion to dismiss the indictment, which included claims that she enjoyed judicial immunity. The 10th Amendment precluded prosecution, and that 1505 should be construed to not cover the conduct alleged in the indictment. Holy goodness. Is anybody else losing brain cells having listened to this? I apologize. This isn't quite as bad as a Bubbles motion, and it's well written by this judge. However, her arguments are making me lose my mind. Absent from the motion was any claim that that person was privileged from arrest at the courthouse, such as that no crime occurred when defendant allegedly obstructed ICE's efforts. Oh my goodness. Defendant replies that the problem was not a defect in the indictment, but a failure of proof. She indicates that the indictment was not defective on its face. It cited a specific federal statute and alleged all of the essential elements. She contends that the factual basis for a motion relating to civil arrest privileges was not reasonably available before trial and could not have been determined without hearing the government's case in chief in full. She continues that the indictment did not establish the privilege's application factually. The indictment also permitted the government to offer a more expansive factual case, which it did. Oh my goodness. The indictment plainly alleged that ICE task force agents had an administrative warrant, they planned to arrest him in the public hallway, and that he was in the courthouse that day to address his criminal case. Yes, domestic battery. Domestic battery. Defendant positions that the government could have offered the evidence that might have taken him outside the scope of the privilege by converting it to a criminal arrest or by changing the location of his intended arrest. But this speculation does not make it an argument unavailable for pretrial determination. The evidence presented at trial confirmed the factual predicate for a privileged argument, as she concedes. Also does not mean the argument could be saved for a post-verdict motion. Tellingly, defendant never explains how her privilege argument fits under Rule 29 or 33. This is what happens when people write documents that are so long. They don't, and this is my problem in another case, where the lawyer, I don't think is a bad person, but when you write so many documents in such a short amount of time, your documents become watered down, and you don't actually address the entire argument or the entire motion or the entire rule or statute, and you leave room for loopholes and reasons like this for your motion to be denied. The argument does not go to the sufficiency of the evidence, nor is it based on some prejudicial error. So second, even if defendant had not waived the argument, even if the district court cases defendant cites are right and Ryan is wrong regarding the applicability of the privilege to civil ICE arrest in courthouse, an issue I'm not deciding, defendants cite no authority that she may assert the privilege in this context. Didn't cite case law. As the government notes, while courts have articulated the policy justification for the privilege in terms of promoting access to the courts and ensuring the efficient administration of justice, in the cases defendant cites, the privilege was asserted by or for the benefit of a party or witness who was subject to civil process or arrest while attending court. In the present context, the privileges would belong to Flores Ruiz, not the defendant. Defendant cites no authority that she may assert privilege derivatively to avoid criminal liability for obstructing arrest. This is where it's like, oh my goodness. yeah, judge, sit down and take your punishment. This is one of those things where it's like she's showing her true colors, and I need to go through the transcript because I am convinced that if we know, I wrote down where in the transcripts, and I'm really hoping it's one of the transcripts that I bought, because I'm really hoping that we can finish that sentence, because anybody who says, and I quote, "Is there anybody else that looks while you're talking about needing an interpreter? Is there anybody else that looks like they don't speak English?" That is racist AF. And I'm not going to hop back on this judge is racist soapbox again, but oy, there's a reason that this judge did not finish that sentence. And I'm pretty sure it was to save her from embarrassment. At least it's real court cases they cite. Yeah, but they don't apply to her. And I don't know, like I said, not a lawyer. I can't tell you what the appropriate case law is, but she didn't cite it, clearly. No court forbids civil ICE arrest in public areas of the Milwaukee County Courthouse or otherwise sanction defendant's course of conduct on April 18th. As the government notes, the operating assumption of those involved in creating a policy was that civil ICE arrests in public areas of the courthouse were lawful, and the judiciary did not have the ability to stop them. I could see not going into a courtroom and affecting an arrest. I totally can see that. Because you're interrupting the proceedings of people who have nothing to do with the individual that you are trying to arrest. I can understand that. However, public hallway? Shortly before the incident in question, defendant was forwarded training materials by one of her colleagues indicating that ICE can legally conduct enforcement, i.e. take people into custody in public areas of the courthouse. So she knew. She knew. Defendant's statements that she would take the heat for her actions and that she was in the doghouse with the chief judge for trying to help that guy. It suggests she knew her actions were not on behalf of the court. This is where if you're going to do something, you keep your mouth shut. You just do the actions. I don't suggest anybody do stupid shit like this. However, this is one of the things where if you do stupid shit, you don't talk about it. We don't talk about the stupid shit we do. Because if you talk about the stupid shit you do, you leave yourself open to it being in court documents and the court record. Because you told on yourself. Keep your mouth shut. Oh my goodness. Yeah, but the thing is it's not about the administration. It has nothing to do with the administration. Like, she's convicted by a jury. Like, that's really hard to overturn. That's really hard to overturn. It's not like a criminal case with DNA evidence that you didn't have in the 80s and 90s, and in the 2000s you have DNA proving you didn't do something. You were convicted by a jury. But it's not going to even work because it's not about the administration, it's about the courts. So even if it does go all the way to the Supreme Court, you're still going to get a court to look at it, not an administration. So that's not the way it's going to work. Yeah, Fleabag is attending the law of lips school. And this judge is going to be teaching an ethics class. Oh, what we need to do, Double Fan, we have to make that. We have to get together the Lips and Luthman School of Law. What not to do. And the worst faculty ever. BBB. Like, and all the people who say I would be mean to BBB recently, I have said from the very, very, very beginning, back in 2024, when he talked about my child choking on an Apple Pencil, that I was never going to be nice to him. I didn't care if it was 2030, it could be 2062. I will never be nice to him. welcome to being a mom and not being a nice person. He didn't do anything to me recently. I just still don't like him, and I'm still going to be rude to him whenever his name comes up because he's a shitty human being. I don't care what he's like as a lawyer. He's just a really shitty human being to talk about and laugh about a kid choking and then lie about it instead of just saying, I fucked up. I was wrong. I didn't mean to do that. I apologize. And, because somebody else has apologized to me for calling me a bad mom. That person and I will probably never see eye to eye on some issues, but I don't hate that person because they apologized to me. I'm not rude to that person because they apologized to me. BBB and the Fleabag have never apologized to me. And I've said, until I get an apology and not more lying about it, I will never be nice to you. Like, it's just not a thing. Like, you talk about my kid getting injured. I'm not someone who's going to be a bigger person and be nice to you. Like, I will be rude to you until like the day you have dementia or I have dementia and I forget who you are. Like, it's not a it's just not a the Thomasis will be a professor. Yeah. The Thomasis will teach constitutional law, right? How to take rights away. This will be our next members only. Oh, like similar to Donald using political. I don't think he used political influence. I think that the charges were excessive for a clerical error, but that's a whole nother topic because clerical error. So yeah, he left my stream and went over and left. But I do want to make it clear because it was misconstrued that he called CPS. He did not. I will clear that up. He did not. However, he threatened to call CPS. Ergo, I went to the police in my town and said, by the way, I've been threatened with a CPS call. I would like to report it. Just in case anything happens, I have it on record and I have receipts. He did not actually call that I know of because that is a can of worms with Mr. Squid that you would not want to open. That's a can of worms that not even I want to open. You mess with that man's daughter, he will do anything from hell to that. We're not going to get into what that man would do for his daughter, but I will be the least of your fucking problems. I'm just saying. Just saying. Yeah. But I just want to make that clear because it has been misconstrued that he actually did. He did not, that I'm aware of. If he did, they never came to my house. I am just saying, I will correct misinformation where it is. And I don't think the people that were spreading misinformation did it purposely because I even commented on that stream that, by the way, so I, just want to make that clear. But if someone did, I will be the least of your fucking problems. You will have to deal with my spouse. Sometimes that's a very scary thing. We're talking about the person who likes to be an asshole just for the sheer entertainment value of being an asshole, watching chaos ensue, stepping back, and watching the bridges burn. That is the person who I love with all my heart. Forewarning. Just FYI, before we, All right. The privilege which is asserted here is the privilege of the court rather than of the defendant. It's founded the necessities of judicial administration would often be often embarrassed and sometimes interrupted if the suitor might be vexed with process while attending upon the court for the protection of its rights, or the witness while attending to testify. All right, the required nexus on count 2. Defendant notes that count 2 alleged violation of 1505 through 5 specific acts. She accordingly argues that I erred in responding to the jury's second question. I should have answered that the question, the question the same, she contends, as I did the question about count 1, that defendant need to know the identity of the subject of the warrant pending proceeding. Defendant argues that the knowledge of the particular, and I still don't understand how they did not know the defendant when she said his name. And she led him out of the courthouse. That's just, ugh. They were talking about felony. I mean, it is called the CPS. They got you confused with LP on purpose, trying to see. No, this was Shizzy and Venom were talking about the issues with when Fleeso was talking about me the other day, and Venom had accidentally said that he called, and I was like, he didn't call. He threatened to call, but he did not call. So it was not the fleas talking about him calling. It was Shizzy and Venom. It wasn't. They didn't do it on purpose. I think they got the facts misconstrued because so much has happened. So, and after it happened, I didn't really bring it up. So, I don't think it was either. So no. I have a Chipotle ketchup in the fridge. Does that count? So, yeah, we're on page 19 of 39. I think we're doing in an hour and a half. We're doing pretty well. Like, yes, and when we have gotten on tangents, it's been tangents related to this. Like her comment that set me off. Like her comment. Like, I just can't. I just can't. Sometimes when people tell you who they are by making comments like that, believe them. Don't just go, oh, she misspoke, or no. When people make comments like she did to her court clerk, who has the whitest name ever, believe her. Defendant begins with the contention that 1505 must be construed narrowly, consistent with Supreme Court's recent decisions in public corruption cases. Obstruction statutes cannot be converted into catch-all provisions where inadequate notice is given to what does and does not constitute a crime. Defendant continues the government should have been required to prove that she had knowledge of the charged proceeding, not a proceeding or the nature of some proceeding. Almost up to tug speed. Hey. Keep, only bring up other streamers when I do. Please don't bring up anybody who I don't watch. Hey. Speaking of cheesy. Cheesy. All right. Defendant further argues that my answer to the jury's second question constructively amended the indictment. No. Oh. Ugh. All right. Broadening the possible basis for conviction beyond those presented by the grand jury. Specifically, she contends the phrase, the nature of the proceeding, is found nowhere in 1505, runs contrary to Aguilar, and its use relieved the government. Holy crap, English is hard. I read the word right, but for some reason the context didn't just make fun of me. Oh, I would love to, but at the same time, I'm getting some freaking amazing entertainment out of the fact that they confuse us. It is much more fun than the last time they confused me with somebody. I wanted to go like drink some bleach. That was easy for you to say. Something like that. And its use relieved the government of proving beyond a reasonable doubt that she knew the administrative warrant in this case was specifically for EFR, the particular proceeding alleged in the indictment. Finally, defendant contends that acquitting on one count, the jury must have found that she didn't know the identity of the subject of the warrant. Fucking Wisconsin. Oh, this. No. Angel. Down. Okay, bye. Bye. I love you. Kiss. No. Okay, no kissing. Yeah, last time was a real insult. Last time I got compared to Georgie. Like the flea tried to say that me and Georgie were the same people. I wanted to choke on bleach. That's all I'm gonna say about that one. Finally, defendant contends that by acquitting on one count, the jury must have found she did not know the identity of the subject, even though she said it. Had the jury been similarly instructed on count 2, a not guilty verdict would logically have followed on that count. Defendant's arguments fail, as the Supreme Court held in Aguilar. There must indeed be a nexus between the obstructive conduct and the proceeding at issue. As absent such a connection, the conduct cannot be said to have the natural and probable effect of interfering with due administration of justice. The instructions included that requirement. As indicated above, the jury told the government needed to prove that the defendant endeavored to influence, obstruct, or impede a pending proceeding, meaning she acted purposely with knowledge that an action would have had the natural and probative effect of wrongfully obstructing the proceeding. Once again, she misconstrued the question that he asked with the stuff that was already in the jury instructions. It's one of those things where reading jury instructions is extremely boring. However, we have proven multiple times on this channel, Nebraska versus a dipshit being one of them, and I'm not saying this dipshit's name, and I will never say his name, because he unalived my friend's daughter. That being said, we learned in that case that jury instructions are very, very, very important to what a jury will find guilt or innocence on. With that being said, they are extremely boring to read, and this just proves that her lawyer did not understand the jury instructions or was ignoring them. I don't know yet. There is an administrative order. I think for later dates. I have to look at what the dates are in that. And thank you for the $50 Ko-fi, Jeffrey Grady. I appreciate you so very, very much. You are amazing, and I hope you are doing well. Can't. Right. Which is proof that, once again, the lawyers didn't read jury instructions. The judge, who is a lawyer, did not read jury instructions. And if they did read jury instructions, their reading comprehension really needs some work. Once again, proving just because you graduated from law school does not make you an intelligent person. The jury was also told the government was required to prove that she did so corruptly, that is, with the purpose of wrongfully impeding the proceeding. By focus solely on my response to the jury's second question, the defendant ignores that the instructions as a whole, my point exactly, and I didn't read this beforehand. The defendant ignores that the instructions as a whole plainly required a nexus between defendant's conduct and the pending proceeding. Reading jury instructions is important. Narrowly focusing on one jury question is going to get you to look like an idiot in a document that some people are going to pay for and read on the internet. You're welcome. Glad I could be of service. At least I'm good at something. Oh wait, in order to be embarrassed, you have a conscience and you have to care. Because at the end of the day, the only person winning in this is the lawyer. Because he still gets paid regardless of whether she's convicted or not. Because jury instructions must be considered as a whole, even if one instruction falls short on clarity, a court must consider the jury properly directed where the totality of the instructions sets forth the proper requirements for conviction. Jury instructions are very important as a whole. That's why it is very important to read jury instructions as a whole. As boring and dry and sleep, if you ever want to take a good nap or you have insomnia, start reading jury instructions. Your insomnia will go away quite quickly. What do you mean they have to read? What the fuck are paralegals for? True. Semantics. Hey, Chucky, how are you? Yeah, I don't think that I think I don't know if she is currently, but I believe one sentencing, and even though they are not looking for jail time, and when she will not get jail time for this, just remember the state was never going for jail time, or the government was never going for jail time. In the indictment, they never were looking for jail time. So when people are like, she's not going to jail, or she's not, no, she's not, because the US government was never asking for jail time. But I don't know what her punishment will be. Obviously, I don't think you can be a convicted of anything and be a circuit court judge, but I could be wrong. Stranger things have happened. In any event, defendant fails to show that my response to the jury's second question was wrong. Once again, you did all this arguing, but you never called me wrong. You never proved while I was wrong. Like my haters. They call me all kinds of names, but you never call me wrong. This question concerned the level of detail needed for the jury to find, as required by the second element, that defendant knew of the pending proceeding. Defendant cites no authority that such knowledge must include the identity of the person or persons involved in the proceeding. In arguing that such knowledge is required to ensure the required nexus between the conduct and the proceeding, defendant overlooks the third and fourth elements, summarized in the preceding paragraph, encompass that the requirement. And here, these elements refer to the proceeding, not a proceeding, not any proceeding or some proceeding. Words are important, and or the really matters. Really, really matters. Yeah, well, yes, but I think one of the reasons that they weren't asking for jail time is because they were just looking for a conviction and precedent that you can't act like this and get away with it. I don't think they were asking for jail time because, in my opinion, it would have made the US out to be look more like the bad guys than they were trying to be. We're just trying to get accountability, and you can't hide behind immunity, not sending everybody to jail. But I think this was more of a precedent case than anything else. Just my personal opinion. I could be completely way off base. I have not talked to any of the lawyers. I am not part of the government anymore, thank God. However, that is just my opinion based on what I would do. Because now this is case law for the next person who tries to pull this. The evidence presented at trial concerned just one proceeding, involved EFR's removal from the U.S. The evidence permitted to the jury find that defendant knew the person whose arrest she sought to prevent was the same person subject to the pending removal proceeding, whether or not she knew his name. The defendant cannot claim surprise at that matter in which the case was presented, nor can she reasonably claim that my answer to the jury's second question permitted the jury to convict based on obstruction of some other proceeding. And I like this judge's writing. I've never really been a fan of this judge. He is a very, very liberal leaning judge. So the fact that he is a very liberal leaning judge in a very liberal leaning city, going against another very liberal leaning judge is kind of a thing. Yeah. I'm not, nope, 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 nope. I can neither answer nor deny, or not confirm nor deny that. I told you. Well, you know the rest of that. Sounded convincing? Nope, didn't sound convincing to me either. Nope. I think YouTube either unsubscribed me to her or she just hasn't come up in a while and I just haven't seen any. In reply, defendant contends she had no reason to know that EFR, as opposed to any of the other people on her docket that morning, was the one wanted for removal. Judge Cervera testified that she and the defendant walked down to the restricted hallway to confront the agent. She heard the name, something about Flores. Defendant's clerk testified that prior to the court starting, he printed out the calendar and placed a copy on the judge's desk. That calendar listed the matter of Eduardo Flores Ruiz. Further, the courtroom recording showed that after clearing the ICE agents from the hallway and returning to the court, defendants asked, "Which client is it?" The recording captured her addressing Flores Ruiz's lawyer, asking, "What's the name of the client?" In response, De La Rosa said the name EFR. Defendant directed EFR quickly became a date off the record before, clearly showing that she knew. A reasonable jury could find that ICE agent told the defendant they were there to apprehend a person who's unlawfully present in the U.S. and that he had an administrative warrant. Cervera also testified that she started to ask to see the warrant while they were still in the hallway, but defendant quickly sent him to the chief judge's office. And as discussed above, it's undisputed that defendant learned the name prior to ushering him out the jury door down the restricted hallway. True. However, how often do we see that these days? Not very often. Oh, she quit streaming and announced it on X. Oh. I don't, with the exception of DMs and maybe posting a stream or two, I don't really ever post on Twitter anything. So usually, federally, I'm not sure. I've never actually watched or been involved in a federal case. I just have access to Pacer and like to read documents on cases that are generally kept from us because there's no cameras in federal courts. However, this one personally affects me because I used to live in this county. So this one might personally affect you because this is Milwaukee County Courthouse. It's a rather large courthouse. All right. So the primary purpose of an indictment is to provide the defendant with notice of the charges against her so she may prepare a defense. It also serves to cabin the government's evidence as to avoid unfair surprise at trial and avoid the possibility of a petit jury will convict on a crime different from the one approved by the grand jury. In some cases, specific language in an indictment that provides detail beyond the general elements of the crime may make the specified detail essential to the crime charged, which must be proven beyond a reasonable doubt. However, an indictment does not, by including certain details about the offense, necessarily alter the knowledge requirements set in the charging statute. All right. By way of analogy, in the felon in possession prosecutions, the government typically identifies the firearm by make, model, and serial number, but no one would argue the government is therefore required to prove the defendant knew the gun's serial number. Rather than in the situation, the government must prove that the defendant knowingly possessed the same gun identified in the indictment. Finding constructive amendment where the indictment charged possession of a Mossberg rifle, but at trial, the jury was shown 3 guns, not just the Mossberg, then received an instruction that it could convict if convinced that the defendant possessed a firearm, in effect, any one of these three. Here, the government had to prove defendant obstructed the same pending proceeding identified in the indictment, but did not have to prove specific knowledge of each and every detail of that proceeding. It seems like common sense, but maybe I'm just common sense isn't common anymore. I just watch Runkle on 1.25 and imagine it's Danny. I don't know if Runkle should be offended by that or take that as a compliment. I'm really not sure. Ah, oh boy. Defendant cites no authority supporting her contention that the answer was wrong simply because the words I used do not appear in the statute. As discussed above, the instructions include Aguilar's nexus requirement and required the government to prove defendant obstructed the proceeding via it's more case law in this footnote, which we don't really care about the case law. If y'all care about the case law, we will go back and read the case law at a separate time. However, and I will research each one of these cases. However, for the nature of this entire document, the case law really just doesn't matter. Defendant obstructed the proceeding, the same one referenced in the indictment. Nothing in my answer undermined these requirements. In reply, defendant appears to argue that I should have answered the question more specifically, noting that the jury asked about the subject of the proceeding while I gave a general answer about the nature. She also suggests the phrase sufficient knowledge was vague. And you know when juries ask questions that judges give them the most vague answers possible. The judges never give them specific answers unless it's a very specific situation with a very specific question. Otherwise, judges tend to give just generalized, vague answers of this area. You'll find it here, or it's in the materials, or you will not get specific answers out of the judge because the judge possibly can see that as swaying the jury. He will give the most god-awful, like, or she. We've seen it in both cases. Everywhere from Sarah Boone to the jury asking a question in, I think, Darrell Brooks with Judge Darrow and Waukesha. It's just, yeah, exactly. Judges usually give vague answers so they don't appear biased, to be swaying the jury one way or the other. That's why sometimes you will get juries that ask the same question 3 times in a row, trying to get something else out of the judge. But, like, it's like, woman, you're a judge. You should know this shit. Did you not read the documents that your lawyers wrote? District judges have considerable discretion on both whether and how to answer a jury's question. Seventh Circuit considers 3 factors: whether instructions as a whole fairly and adequately treated the issue, whether the supplemental instruction was a correct statement, and whether the district court answered the jury's question specifically. For the reasons set forth above, the instructions as a whole fairly treated the issue. The breadth of 1505 is indicated. The government charged defendant with concealing CFR or EFR from arrest. We already know that. And the government charged defendant with concealing from arrest, 18 U.S. Code 1071, a misdemeanor, and obstruction of EFR's removal proceeding under 1505, a felony. Defendant argues that nothing in the text or history of 1505 demonstrates congressional intent to make a felony the same conduct labeled a misdemeanor under other statutes. Well, sucks to be you. Where the Supreme Court reversed the conviction of a January 6th defendant under the Otherwise Clause, holding that the scope of the clause must be limited to the specific examples list in 1512c1, which pertain to records, documents, or other objects. She relies on Justice Jackson, of course she does. Concurrence, which noted that nearly all of the broad, all-purpose obstruction statutes that various states have enacted are classified as misdemeanors. Oh, let's see. Defendant also cites Marinello v. U.S., where the court reversed an obstruction conviction under the Omnibus Clause, relying on Aguilar. The court held under this clause there must be a nexus between the defendant's obstructive conduct and the particular administrative proceeding, such as an investigation or audit, or other targeted administrative action. All right, defendant argues in this case the government turned a misdemeanor obstruction of an arrest into a felony obstruction of a pending proceeding. Oh, poor baby, poor baby, poor baby. She argues that under this construction, a potential arrest of every illegal immigrant in the country is part of a pending administrative proceeding. Well, it is. She concludes that under the reasoning of Fisher and Marinello, the guilty verdict on count 2 should be set aside. In the alternative, the court should grant a new trial with proper instructions. See, this right here, I don't care. I care, but I don't. The court should grant a new trial with proper instructions. Because your lawyer didn't argue jury instructions properly is not this judge's fault. That's a you problem. Every lawyer has the opportunity to argue for the addition or the withdrawal of certain jury instructions. Your lawyer sucks. Like, you don't get a new trial because your lawyer didn't argue jury instructions properly. Like, sweet Jesus. We're doing just fine. This is a 39-page document. If we go over a little over 2 hours, it is what it is. Generally, we like to keep them around 39 page or around 2 hours. However, this is 39 pages, and we're on page 27, so we might go over, but that's okay. That's okay because of the fact that this is 39 pages, and I am not going into this document again once I'm done with it because I can't afford to lose any more brain cells with another brain dead attorney. Hey, two awesome dogs. How are you? Yeah, we try to keep streams here under 2 hours because over 2 hours, I know replay crew gets a little. I don't like to watch streams that are over 2 hours. My damn self. On replay crew, live streams fine, but on replay crew, I don't like to go over 2 hours because I ain't got time. So I try to be respectful to the replay crew. However, in certain instances, outside of court hearings, we sometimes have to. So government argues that there's a little overlap between 1071 and 1505, and the latter requires the person to act corruptly with an improper purpose and is focused on an obstruction of a proceeding, as opposed to the concealment of a person. In any event, as the Supreme Court noticed, redundancies across statutes are not unusual events in drafting as so long as there's no positive repugnancy between two laws. A court must give effect to both. So, let's see what she, nothing in the court's reasoning implicates defendant's conviction on count 2. Section 1505 contains one obstruction provision rather than two provisions in 1512 at issue in Fisher. Defendant cites no legislative history suggesting that 1505 must be construed narrowly as she contends. This judge is getting salty. Well, Fisher mentions that this judge is a very old judge. I think he's in his 60s or 70s. Like as far as judges go, like he's been on the bench for a long time. He's almost like Hinkle, except really, really left-leaning, whereas Hinkle's kind of like more moderate, little ish. Take that one with a grain of salt. Where this dude is super liberal, and most of the time his rulings reflect that. Here it doesn't. I'm actually shocked. And the people who I've talked to about this, who live in Wisconsin, are quite shocked as well. They haven't actually read the document, but it's all over the news up there. So, See ya. Bye. Squid, you see the smoke signals John Cook was sending 2 days ago from your place? For my place or from my place? Because my place don't look like that. My place was built in 2020, 2023, 2024. My house is new. All right. The court did not discuss the meaning of the statute or the term proceeding. Finally, the government notes Congress may have intended the harsher penalty in 1512 up to 20 years to apply to a person who obstructs an official proceeding, as opposed to the lesser penalty up to 5 years that applies to those who obstruct any pending proceeding under 1505. And as the government further notes, courts have construed the statutes differently because an official proceeding must be different than any pending proceeding. Defendant replies on none of these cases cited by the government construing 1505 involved an ICE arrest as part of removal proceeding, but this simply reflects the fact the statute applies to many different agency proceedings. It is no reason to disregard the manner in which these courts construed the key term. Defendant further replies that these cases predate Marinello and Fisher, which marked a shift in the manner in which court interpreted obstruction statutes. As discussed above, however, the instructions in this case include the nexus requirement. In other words, defendant could not have been convicted based on her obstruction of some unknown proceeding in the general work of Department of Homeland Security. Legal acts. Finally, defendant argues the verdict in count 2 was based on conduct, addressing a case off the record, directing him to leave through a jury door, and permitting to appear by Zoom. That's not inherently illegal or corrupt. Instead, she was convicted based on acts that were part of her job and within her authority. No. No. Oh boy. These arguments are largely a rehash of those presented in defendant's previous motions and her proposed jury instructions. Just because you rewrite something and repackage it as a different motion doesn't mean your facts are different. Your examples are different, your case law is not different. You just repackaged it and retitled it as something completely different when it's not. It's the same shit. It's the land. I live in the site of Civil War battlefields. I live near a POW camp. I live near Revolutionary War battles as well. This is very tainted land. We live near Revolutionary War cemeteries. We live near old shit. As I noted in denying defendant's motion to dismiss, there's no basis for granting immunity simply because some job allegations in the indictment describe conduct that could be, keyword, considered part of a judge's job. Further, as I noted in denying her motion in limine, otherwise lawful conduct can amount to a crime if done with corrupt motives. And when you say, I'll take the heat, that screams corruption. Defendant argues the term corruptly should be limited to inherently evil conduct. You can be corrupt without being evil. There is a difference. Tanner, what's his fuck? Evil. Certain other people, corrupt, maybe not evil. And that there's no evidence that she engaged in corruption in the ordinary sense. Instructions here included the definition of the term corruptly adopted by Congress. Defendant cites no authority that conviction under 1505 cannot stand, absent evidence of extortion, bribery, or destroying evidence. Contrary to the suggestion in the original motion, the instructions here required the government to prove defendant acted with improper purpose. Defendant suggests that the term corruptly requires a defendant act with the intent to procure an improper benefit for herself or some other person. Okay. This statement right here, we're going to read this slowly. Defendant suggests that the term corruptly requires a defendant act with the intent to procure an improper benefit for herself or some other person. Wouldn't helping someone evade an arrest be a benefit for that person? Once again, she argued against herself. And the fact that you argued against yourself and you can't even fucking see it is absolutely ridiculous to me. Absolutely ridiculous. I mean, improper benefit for some other person would be helping EFR get away from his removal proceeding. Just a thought. Just a thought. Defendant further argues the instructions left no room for good faith. You wouldn't know good faith if it smacked you in the face. Defendant did not request a specific jury instruction on good faith. Your lawyer, and you, because you're a lawyer too, you could have spoken up to your lawyer and said, hey, bingo, ding, 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 ding. We have a winner. They're the best example recently of someone who argued against themselves. Also, their jury instructions left no room for good faith. The defendant did not request a jury instruction on good faith. Oh my goodness. Yeah. Defendant next takes issue with the definition of endeavor. She takes issue with everything. Let's just be honest here. Which permitted the government to argue the crime was complete as soon as she allowed Flores to leave through the jury door, regardless of the fact that he emerged into the same public hallway where the agents were waiting. I drew this instruction from the Seventh Circuit's pattern for 1503, which makes clear that endeavor need not be successful. You don't have to be a good criminal or a smart criminal to be a criminal. You don't have to be smart to break the law. For an improper purpose, defendant repeats an argument made to the jury that he emerged into the same public hallway less than 12 feet from the public courtroom door. Hold on one second. Say hi. Yeah. No tears are necessary. We're all right. It's okay. All right. Yeah. You want to read this with me? Defendant also fails to appreciate, so long as the government proves corrupt intent to obstruct, it does not matter that her endeavor did not succeed. You don't have to be smart to be. You want to get down? Okay. Oh, kiss. I love you. I love you. One. All is good again. This provided the as discussed above, the endeavored instruction required if she had acted purposely with knowledge that an action have a natural and probable effect of wrongfully obstructing the proceeding. This provided the required nexus. Seems like common sense, but ugh. Don't insult potatoes. I watch Charlotte Dobre. She's one of my favorite channels on YouTube, and we are all petty potatoes. She is our petty potato queen. Don't insult potatoes. Yes, mama duties are activated on this channel on the regular. So it's a thing. It's a regular thing. Defendant next disputes my refusal to give materiality instruction, but she again cites no authority for its inclusion. Instead, she cites this case, a mail wire bank fraud prosecution, and civil instructions and patent infringement and employment discrimination cases. Further, as I noted in jury instruction decision, the definition of endeavored used in the instructions permitted defendant to argue her conduct did not have the natural and probable effect of wrongfully obstructing the proceeding. Okay, you want to read? Say hi, Uncle Buck.
Hi.
Here we go. We're going to
Hi.
yeah, Bull Pucky. Bull Pucky. Say Bull Pucky.
Hey,
Did you
Bucky.
probably shouldn't have said that. The government responds that aside from the fact the statute does not require successful obstruction, defendant's course of conduct that morning changed what was supposed to be a low-key arrest by a team of agents into a foot chase through moving traffic by a portion of the team. Yes, she forgets that her actions led to them having to chase him across a busy street. Mm-mm. We're gonna come up here. You want one? Hold on. You want this one?
No.
Okay. You want to check Grandpa? Alrighty. She fails to remember that her actions led to a foot chase through moving traffic. Defendant argues the jury instructions gave no context or guidance for how to consider.
Mommy.
Yes. Okay. You got integrity.
Mommy.
Yes.
Yeah.
She points to her proposed instructions that a defendant who has a legal right to act as she did does not corruptly endeavor to influence, obstruct, or impede. She did try to argue and instruct in jury instruction. I rejected this and similar instructions as a rehash of her immunity argument, unsupported by case law. You can't hide behind immunity, chica.
What?
Did Grandpa reply? As I noted in denying the motion to dismiss, there's no basis for granting immunity simply because the indictment described conduct that could be considered a part of a judge's job. I feel like I've read that 5 or 6 times today. Defendant's contention that she was authorized to act as she did, regardless of motive, finds no support in the law. Just because you are a judge does not mean all of your stuff. Okay. Hold on 1 second. I have to return a text. Okay. Bye. Kiss. Love you. Okay, stay that way. We have 4 pages left. Probably 3 with the, end of it. Defendant complains that I cited no authority for limiting legal rights to taking the Fifth or asserting valid privilege. As citizens retain all sorts of rights not specifically enumerated. We don't need to spell out all of your rights in every document to know that you have them. We have this thing called the Constitution. But, in reply, defendant contends that by denial of her proposed instructions, providing that acts of a defendant has a legal right to undertake did not violate 1505, wholly negated state law as a source of lawful authority. In these instructions, defendant proposed the jury be told that state court judges' official acts, including the acts that were part of her job, did not violate count 2. Those proposed instructions then told the jury that it could not consider in any way the claim that defendant did the various things charged in the indictment, i.e. telling the agents they needed a judicial warrant when they didn't. As I explained in my order denying the motion in limine, and again in the instructions decision, these arguments essentially requested judicial immunity for the acts. She keeps repackaging this judicial immunity under different wording. She keeps repackaging judicial immunity under motions in limine, motions to dismiss, motion for a new trial. Your judicial immunity does not matter. Multiple judges, the magistrate judge and this judge, have all said your judicial immunity does not cover this. Stop asking for it. And yet she still tries to argue. If you are trying to hide behind immunity, you know you screwed up. It's as simple as that. Defendant takes issue with the concept that corrupt motive can make lawful acts unlawful. Defendant attempts to distinguish Cueto because it involved 1503, not 1505. However, the operative language in both statutes is the same. 1503, Whoever corruptly or by threats or force or by any threatening letter or communication endeavors to influence, intimidate, or impede any grand or petit jury or officer or in any court in or of any court of the U.S. 1505. Whoever corruptly or by threats or by force or by threatening letter or communication influence, obstructs, or impedes or endeavors to influence or impede due and proper administration of the law under which any proceeding is being had. Depends on if you were legally or illegally and what you were being snuck out of the courtroom for. I'm pretty sure that she wouldn't have tried to sneak your ass out of the courtroom depending on what you look like. I don't know what you look like, so I got nothing for that. But I don't know. The fact that earlier in this she told her court, is there anybody else in the courtroom that looks, talking about needing an interpreter. She's a very interesting personality to me and someone that I would never want to associate with. So defendant correctly notes that Cueto's other legal conduct was motivated by his desire to protect illegal gambling operation and safeguard his own financial interest. But nothing in the court's decision suggests the improper motive must be a financial one. She cites another case, but defendant also contends in the reply that the court's instructions denied her a perfectly valid defense, the privilege against civil arrests in courthouse. Oh my God. Defendant requested no instruction touching on the privilege against civil arrest in a courthouse, just as she did not raise the issue via pretrial motion. She was so focused on her judicial immunity, in my opinion. They were so focused on the judicial immunity being the crux of everything that they forgot to possibly argue things that might actually have worked. It just, you know. Defendant requested no such instruction. Finally, defendant reasserts her immunity and 10th Amendment arguments, previously rejected in the motions to dismiss in the indictment. In light of the full trial record, defendant provides no new authority or analysis to decline or revisit those rulings. Therefore, it's ordered defendant's motion and renewed motion are denied. 6th day of April 2026, Lynn Edelman. We made it through the whole thing, guys. We did it. We did it. We made it. We made it. Oh, thank goodness. 39 pages in 2 hours and 17 minutes. All right, guys. That is all I have for you tonight. Sunday night, we do have on the other channel, we do have the How to Get Moving When You're Scared of Pain, which I am actively working on. I am also working on a couple of videos for both this channel and that channel. It's just getting the ability to sit down and work. Where both the time and the energy all meet. Because usually something's either going on, I'm tired, or other things take priority. So, yeah, you know, it's I have a lot of ideas and not a lot of time. With that being said, I am going to see where we can go. I know that Shizzy and Mo Shizzy and Mo are at 8 o'clock. Oh, but I'm going to see if they have their stream set up yet, because it only matters to redirect if we have, you lost me 25 pages ago. You know, I got, Nick Starro is still live, so Nick Starro is probably going to redirect to Mo and Shizzy, so we'll head over there for the time being. Y'all have a great night and tell them I sent you. Bye, guys. I will see you on the next one. And remember, don't be a twat waffle and don't be an ist like this judge. Bye.